capturing.
So it is, so here it's 5:03 on April 1st, 2026. We are here for a zoning ZBA meeting regarding Assessor's Parcel Map 5-A-4.2, deed recording book 19519, page 438. Address is 212 East Hill Road, and this is on behalf of Chris and Crystal Harry. The applicants are appealing zoning enforcement action on their auto detailing business, which is operated in the agricultural residential district. Go ahead, floor is yours.
Oh, I just have an opening statement, and then I'll let you folks ask any questions you need to.
Okay.
Good evening, my name is Christopher Harry. I'm appealing the zoning enforcement order issued on December 9th, 2025. This appeal is not about seeking a special permit or expanding any use. It's about ensuring the zoning bylaw is applied as written. Section 3.4 of the bylaw explicitly references section 3.2.5, which governs home occupations. The enforcement action concludes my use is not permitted, but it does so without applying section 3.2.5 and without any findings under that section. There was no site visit, no documented impacts, and no opportunity for discussion prior to the cease and desist being issued. I am respectfully asking the board to reverse the order and at a minimum, remand it for proper evaluation under 3.2.5.
Okay, any questions? What is your evidence that you qualify under 3.2.5 for an accessory use?
Hold on a second, I'll pull that up for you. So in 3.4, it states for agricultural residential, all uses permitted in a residential district.
Mm-hmm. And I didn't see all the detail in there.
There's also no mention of any other businesses. It's just a wide. It says accessory uses customarily incidental and secondary to the residential use, including but not limited to, and then it lists the use of rooms is a dwelling or accessory building for a customary home occupation conducted solely by a resident with no more than two persons besides the resident in the practice of a recognized profession.
Which auto detailing is not a recognized licensed profession.
What is a recognized licensed profession?
Real estate, attorney, licensed contractors, licensed electrician, licensed plumber, those are all recognized professional industries.
So just so I'm clear, it says in the practice of a recognized profession. It doesn't say license is required or list any.
Well, profession tells me professional, tells me licensed. My understanding.
Can I ask a question, or when do you?
In moments.
So based solely on how the bylaw is written, it does not negate me being able to operate this business.
It doesn't give you permission either.
So if that's the case, then any other business outside of lawyer, accountant, anything is not allowed.
Unless they've applied for a special permit, gone through planning, conservation, and all the steps that would allow it. And then they come through us and it's approved at the end to get a special permit or variance to do that in those areas. But unless that's done, it's not allowed. John, anything?
I'm listening.
Okay. I'm strictly by, these bylaws, we work with these, and I couldn't find anywhere where it's allowed, even in an accessory use.
So if that's the case, then in 3.3, residential districts is also part of 3.4 then, may be permitted by Board of Appeals. It has that listed as well. So the things you're saying that wouldn't be listed, you hold on a second, you said if it's not a licensed profession, which doesn't say licensed in the 3.2.5.
This is a profession, so I'm a recognized profession to me, license required, to me, my opinion, but go ahead.
Okay, so then those in 3.3 would be allowed by the Board of Appeals. So that's also not listed auto detailing in there, so you couldn't approve those.
Not based on this.
So
It's
no
not
business,
listed- It's not listed in an approved use of a residential area. It
So-
would be a commercial use.
so no business other than a licensed profession, in your opinion, can be operated in the agricultural residential district. Because 3.3 says specifically what can be allowed by the zoning board of appeals.
Right? Golf courses, different things, yeah.
So you're saying 3.2.5 does not apply?
I don't consider it to be an accessory use.
On-
In my
on-
opinion. Anybody else?
On what grounds though?
It's not a recognized profession.
So I have accreditations, I have licenses, I have that stuff.
Okay.
So paint correction, in a sense, not painting, obviously. Paint correction is not a profession. You can't, I think profession to me is you make money doing it in a capacity as you're an artist and you're good at what you do. That's a profession, not just what you determine it to be based on not having a license.
Well, I think it's pretty specific with the things they listed that were allowed. And that's producing things. Is this a carpenter, electrician, painter, or?
Well, I wasn't specifically saying I'm an artist, I'm just saying, if you're talking about the generality of saying that I'm not allowed because I'm not listed, and you could only approve the things in 3.3, and no
But that
actual,
would be by-
hold on one second,
that
no
would be by
actual
special
professions,
permit.
no actual professions are listed in 3.2.5. So it's only under you're able to,
Carpenter, electrician, plumber, those are professions, those are all licensed. Machinery, they can't have any other machinery, but you can produce things. So no manufacturing or business requiring heavy machinery or substantially continuous employment. So visible or audible to the public.
And I think
What
it's
is others?
3.2.5.2 calls out use of the premises or building thereon in connection with his trade by a resident artisan who works primarily away from the premises. So,
yeah, I wasn't calling
do
myself an
you-
artist, I should have not said it.
no, it's okay. No, I'm calling out the words primarily away, right? So do you, in your business, do you typically go to the customers and then you come back and
I do both, depends on what if the customer can't drive because they're elderly or if I need to help them out, then yeah.
But is it primarily off-site or is
No,
it
primarily
on-site? So I think that's the differentiation here that needs to be called into attention. Because I think this is calling out 3.2.5.1 goes hand in hand with 3.2.5.2 and further calls out that yes, say you're a carpenter or a plumber, you come home, you've got work to do. You can't be prohibited from that, right? But it shouldn't be visible or audible to the public or others, right?
Yeah.
But it sounds to me like most of your business is taking place on premises, correct?
Yes. So effectively you're saying by 3.2.5, the original paragraph, accessory use is customarily incidental and secondary to the residential use, including but not limited to the following. So you are limiting it by saying that the auto detailing business does not qualify.
Well, I think, Chris, this more pertains to an accessory use of maybe a room in the house or something like that, renting rooms or using a room in the house, or doing something else like that. That's just their home base for their business. That's not their primary place of doing it. Like these people are going out to houses and painting, doing contractor work, plumbing, electrical, all that stuff. So those are things that are all done elsewhere.
So that's not what 3.2.5 says. That's what 3.2.5.2 says. That's a totally separate paragraph from 3.2.5.1, which is identifying something else. It's not a subparagraph of 0.1. Those are subparagraphs of 3.2.5. So that's the overarching application.
Well, overarching is customarily incidental and secondary to the residential use. Does that qualify here? It's your home, right? But
Yeah. I guess what I'm saying is if you are limiting auto detailing, even though it says including but not limited to the following, so you can broaden 3.2.5.1, 3.2.5.2, 3.2.5.3, you can broaden that. You can't make it more strict, but I mean, you can, it's your choice, but if you're not allowing my business, and what's the metric to hold up to the next business,
Yeah.
it's a little different. If it's not in the bylaws specifically that, first of all, the original complaint, one of them was that I'm dumping chemicals, which couldn't be further from the truth. So, not doing that, no pollution. Board of Health was invited to my property, they didn't come, they said they don't have to. So there's nothing going on that's impacting any of my neighbors in any capacity. So there's no issues there. And then, so if you say no, you're limited what businesses can operate then.
Mr. Chairman,
Please.
I'd like to point out that section 3.2.5 refers to accessory uses customarily incidental. That has a meaning in the law. That means that it has commonly, habitually, and by long practice been established as reasonably associated with the primary use. So before you get to any of that other stuff that you're talking about, you have the burden of proving that in the town of Brimfield, that it is commonly, habitually, and by long practice been established as reasonably associated, your business, with residential use. It's your burden of proof to prove that.
So-
That's step one, before you get to any of that other stuff.
So in a town of 3,600 people, if you start a new business, candle making, anything, that hasn't been customarily done in Brimfield,
It's not an accessory use, yes, that's
so,
correct.
okay. So your definition of long-standing and been done for a long time would be what then? As the lawyer.
It's not my definition, that's the established case law in the state of Massachusetts, that's the established case law. So your burden is to show that commonly, habitually, and by long practice, it has been established in the town of Brimfield that an auto detailing business can be conducted with a resident. So maybe you have evidence of that, but that's your burden of proof.
So the fact that the complaint was from a sole person, no neighbors complained, nothing to that effect, no evidence was actually gathered, the wrong website was referenced, the incorrect business name, nothing matters getting to this point, you're saying.
I agree, I don't think that's relevant to the appeal of the building commissioner's order.
All right, in my opinion, if you rule against me doing this, you are placing the burden on every other business in town that's not been customarily operating for a set standard amount of time. So that really puts a target on any business in town, if that's a ruling.
And it's operating in a residential agriculture or residential district, not in a commercial district. This would be allowed in the commercial district.
True, I agree, but no question. But applying this here does start narrowing the scope of what's allowed in Brimfield or not, to the point where
I
any
think the
business,
bylaws already did that.
your interpretation of the bylaw did that, yes.
Well, this was something that was set up without permits or without going in front of any boards to do. You just opened it up and started doing it.
What do I have to do for that though? I have an LLC.
Register business with the town.
I don't, I have an LLC. I was told I didn't have to by the town clerk at the last election at the church.
Okay?
I was told
My LLC.
you can, the what?
I have an LLC and the town's fully aware of it.
They may be, but they don't have to be.
They are.
But that's still not a law. That's what you wanted to tell them, so.
So they could tax me on things. I own equipment, and certain things that they could tax me on. That's
Yeah,
all.
I don't have anything outside of drills and vacuums, so.
You stated there's no runoff at all. Do you have containment?
So, I use products that are absolute zero impact on the environment. It's my well. I'm operating on top of the well for my family drinks out of.
Well, so we all know it runs downhill, right?
I'm just saying, it's,
Yeah.
that is the property, so it's gonna include wells, which should be mine. So I use chemicals, a chemical for soul washing, that's actually water, that's a waterless wash. You can do it in a bucket in the minimal, it just dries up on the driveway essentially. And paint correction, there's no liquids to touch the ground. That's it, it's compounds, polishes, polish the car, wipe it off into the trash. And like I said, the Board of Health is aware, I invited them to the property.
And they did not say it was within their jurisdiction to inspect, or?
I was told at a select board meeting that they were notified the same day the complaint was filed by Mr. Kelly, that he had also told the Board of Health, when I contacted them, they had not been told about it, and I, at that time, invited them to my property anytime they wanted to come. So,
So, I would question if you do, said it runs off into the driveway, dries up, the next rainstorm can reactivate it, just like salt. It's no different. And another neighbor was concerned about it because of the stream right next door and the runoff going towards a vegetable stand. So there is some concern. I'd like to, at this time, open it up to the abutters. Any abutters here? And you are? Well, go ahead, you didn't raise your hand.
Previously raised my hand. So actually, I have one.
What's your, I need your name and
My
your
name
address.
is Neil Collins Lovell. I live at 215 East Hill, right across the street.
Okay.
So I have one comment and one question.
Sure.
My comment is that as a neighbor, this business has not had any impact on me whatsoever. It's not something I routinely even see, and certainly makes no noise. I also have not seen any runoff that would come by my house. Haven't seen that either. So as a neighbor, I actually support this business. I think that it's a good thing to have in our neighborhood. It has no negative impact on me or my family.
Okay.
My question is about this, the comment about how if it's not a routinely established business, I don't have the exact language, but what happens as businesses and professions change? This is a general question for the board, right? So as new professions emerge, they can't be routine, right? If they haven't been established yet, how do we make room for new businesses and professions in our community? And there's a question sort of related to COVID. Like a lot of us work from home. We do provide services in our house that were not previously provided from home, but we're working from home, right? So that's an interesting way to think about it. My father, who's now retired, was a photographer. He used the house as a home base, right? He went out, he did things, he did stuff at home. So I think there are a lot of people in Brimfield who have businesses that are partially based at home and probably not registered with anybody because it's pretty vague, you know, sort of. Anyway, but my question was, how does the board then incorporate or contemplate new kinds of professions that have not been routinely established previously, but may be something that people need to do from home in the future? You don't have to answer it, but I think it's worth thinking about.
You could, my thing would be that it would have to be brought up to the bylaw committee to change the bylaw and present it to them for that purpose, and then it would be voted on by the town.
Including things like people who work remotely from home?
Yes. If it's not here and you want it here, you have to present it to the bylaw committee and have it written up and it gets voted on.
Yeah, it seems like a lot of people are probably working from home now.
But mostly on computer, I would say.
Yeah.
Nobody's bringing patients to their house. I know somebody that reviews x-rays from home.
I think working from home is different than running your business out of your home too.
Right. So,
Unless
it's not your business. You're working for
lots of people
somebody
do
else.
work from home, and it's
Yes.
also their business that does happen.
And that is, you're allowed to work from home. So,
I just want to comment further on that. You were saying you can work from home,
You
not
can
in a
work
recognized profession, but mine's not allowed because it's not established over time.
you're correct, because anybody could work, all these other things were accepted. Yours is not on there.
What other things?
I believe it said lawyer, it didn't say lawyers, doctors.
It didn't say, where's that?
Yours is-
Yeah, I guess just the thing about not limited to, that phrase is a bit confusing. I also don't understand to what.
Once again, that's something that could be addressed with the bylaw committee.
No, I'm saying it already says that. It says not limited to, yeah.
But it does say, home occupation conducted solely by a resident with no more than 2 persons beside the resident.
Which is true.
And that's, psychology profession,
But why is
some
that
things like
different
that.
than auto detailing? If it's one person.
I don't know.
It's not. It doesn't seem like it would be different.
It's considered to be different.
What indicates that it's considered different?
It's not, we have an approved track record, like Richard said, of a home-based business being an auto detailing company in town. That's home-based. I mean, on Route 20, we have some companies that do it, but that's the commercial zone, so it's different.
Yeah, it would be confusing to me the way it's written. It doesn't indicate that it's not included because it says not limited to, right?
Mm-hmm. I guess somebody interprets things differently.
So,
Okay, and you are,
Callie Knoll, my husband David Knoll, we live right aside of Chris,
what number?
208, right aside of him. Absolutely no issue whatsoever. If you see one car on a weekend in his driveway, that's all you will ever see. If you even see that. There is not like some big business going on over there. One car on a weekend. Parked. And by the way, everything he's doing, I'm doing. I have the same stuff I wash my car with, the same blowers, the same vacuum cleaners, same thing.
Mhm.
This didn't just happen. He didn't just start this business. He's been doing this for years and years and years. Why now?
So it doesn't matter how long somebody's been doing it, when a big sort of, when it comes to our attention, it's taken care of.
Right.
If somebody was running an illegal antique shop, they would be reported. If it's when it gets reported, and nothing until it gets brought to our attention, or the building department, he's the code enforcement officer, it has to be brought to his attention. There's a 2 or 3 page document you have to fill out. Somebody has to file a complaint. And until that time, nothing's done about it.
Just a little suspicious, that's all. That all of a sudden it happened. Suspicious.
Anybody else?
David Knowles,
Okay.
husband. My question is, another business on our street, Caroline's Quilters,
Mhm.
is she registered? There are people that pull up, there's a shingle over her door, or has been.
I don't have the answer to that question.
Okay, there you go, the proof.
Proof of what?
That she's running a business out of home where people actually go to her residence.
Okay.
He takes a vehicle there.
I-
It's not like there's people
I don't
marching in
know
and out,
if she's
it's
a
not a
registered-
traffic issue.
Business, if you wanna find out, you can file a complaint with Bill, and he can take care of it.
Okay, I don't wanna put her out of business, she's retired, husband on duties. But I'm saying, what about the guy that's cutting wood, has a truck there, and he's going in and out of the stuff? And it's not a nuisance to the people that see his truck going up and down the road. I mean, there are so many
Cutting-
small businesses,
cutting wood.
as Camille said, post-COVID, changed the whole dynamic of our economy. And he has been making a living, part-time for over 10 years that I've known this done. And we believe that this was something personal that was against him.
But I just wanna explain, cutting wood isn't allowed to use on agricultural land.
Pardon me?
Agricultural res, cutting wood isn't allowed to use.
Is allowed to use.
Yeah.
Okay, but I'm saying, but he didn't apply for the business like you said Chris has to.
Is he running a business selling wood?
No, I'm using for instance.
He could be. He could be.
So some people have businesses cutting wood and they have the land to do it, and it's an allowable use.
Right.
It's
I agree.
agricultural. They
But I'm
grow
saying,
trees to cut
but
them
they
down. and split
registered
them
with
and
the
sell them.
town. If they're
They
just doing
have to
it
be.
they work a 9 to 5 or a 6 to 6 job every day, they come home and cut wood for the rest of the week.
Well,
It's a part-time venture, because that's what Chris is essentially. He's a full-time employee, 8 to 5 every day, but this is his part-time extra money that I know he uses. He has a daughter who likes to ride horses. That's an expensive hobby. That's why he does this.
I appreciate that. I just want to add, we're talking about, everybody's got great points about whether it should be allowed or not based on current situation, how it's written. I think you're limiting the town, anybody that wants to open up a new business that's not listed in those things, they can't do it then.
then, like I said, you present to the bylaw committee why something should be in there, and then the town gets to vote on it. The town writes the bylaws. They decide what goes in and what doesn't. And these haven't been updated, because the last time this one was updated.
23. Well, I don't know when that one was specifically.
But this, I mean, some of these things are adopted March 1975, for 3.5, 3.2. too.
I guess this clearly sounds like you're not in favor of this at all. So what I'll say is, you ruling against this does impact every other homeowner in this town who wants to operate a business, to the point where you're limiting, you could allow this tonight, based on how the bylaw is written. It says those things, but not limited to. So you could allow this tonight.
That's an opinion.
Yeah, it's the fact, that's how it's written.
It's an opinion.
I have a question. I'm really fine. What is the point?
Kim, you're not a butter, so you cannot speak. Okay?
So, I'm saying, it may be your opinion, my opinion, whatever the opinion is, the bylaw is written to the fact to not limit residents. That's why it's written like that. I'm reading it, that's how it's written. It's these things, but not limited to, so you could expand and say yes tonight.
Right? Yeah, it's gonna be a board decision. It's a unanimous decision from the board to do anything. Do we need to, Deb, do you think we need to read the other neighbors?
Sure, if you'll let me, I just need to correct something that you said. The bylaw does not get changed because you bring it to the bylaw committee. The
That gets
bylaw
voted on.
committee, Camille is actually on the bylaw committee, but a citizen can do a zoning bylaw change, there's several steps involved, but a citizen can petition to do it. So if after this hearing, someone wants to petition to change a zoning bylaw, there's a whole process to do that. And it goes to town meeting. It's a little bit too late for this year's town meeting, but it's not just to the bylaw committee will review it. So, sorry, I just had to say that. Yes, okay. To whom it may concern in the town, as far as bylaws are concerned about putting a car dealing facility
Detailing.
2 houses up for me, I can only say one thing. The runoff of the cleaning chemicals will literally go underneath my farm stand and into the brook, which eventually makes its way down to Lake Sherman. There is a farm across the street, and there's mine 2 houses down. This was and always will be a farming community. Also, I don't wanna listen to cleaning equipment all day long.
What resident was that?
Excuse me, you should identify who.
Yeah,
Yeah,
Mike Boyard, 220.
Mike Boyer, 220.
oh,
He emailed because he was not able to make the meeting.
that's fine. So those, again, those are opinions, because I have other residents that live directly across the street that has never seen runoff. And that's true, right? And then I don't believe anyone else has any documented concerns with sound that I know of. No one's ever said anything to me, so. I'm sure at this point, somebody would call the police probably, right? If there was noise after a certain time, or, I'm just standing on the fact that if you rule against this, you're narrowing what residents can do in town. I don't think that's what small government should be doing.
Can I ask a question? What is the purpose of this bylaw? What is the purpose?
To regulate things that go on in the residential and residential agricultural business district. They don't want businesses, businesses that are running in households that shouldn't be running in households. That's what it was designed for. So if you run somebody's painting cars, you don't want that going on next to your house, right? Auto mechanic, you don't want that going on next to your house, a lot of noise. So that's why we have the business district for businesses. So, okay, any questions?
This seems to me to be right on the fence between something that should be allowed and shouldn't be allowed. I would agree if it's a mechanic or something, you know, maybe it shouldn't be allowed. I don't know about the detailing. I don't know how much chemical runoff there is. I don't know how we could find that out. It doesn't sound like there's any problem with noise from the neighbors. He didn't complain about the noise, he said the noise he would hear. It sounded like he didn't even know what was going on already.
He knows what's going on.
They're a lot closer than what ours.
I'm gonna be very honest. I've been doing this since 2019. Everyone around me knows what's been happening. I've said it in the open session. Mr. Kelly dropped his friend off to pick up a vehicle at my property, so he knew what was happening then. And then at this point in time, it's now being brought forward as an issue, which I don't understand the whole timeline and process, but
It happens. People do stuff illegally for years and don't know it.
plus it's illegal.
We had, or it's not licensed, it's not, you're not registered with
It
the
doesn't
town.
have to be licensed, I don't have to be registered with the town. If you,
Just
please tell me the law, or the lawyer can
People
tell me.
do things
I
that they're not
understand,
supposed to
but you're making
be
it sound
doing.
like that's me
No,
doing
no,
that.
people do things that they don't know they're not supposed to do for years and years and years.
Except it is a business being run out of a house.
And so would a computer repair person who operates virtually. If they own the business and operate out of their home, then they're in this same circumstance exactly. Whether it's auto detailing, IT support, networking, if they own the business and they operate in their home, this is the same ruling.
So, Mr. Harry, I agree with you, right? It's a slippery slope, and I think the decision tonight could impact other businesses. And the question is, where do we draw that line? And let's say Amazon wants to put a warehouse in next door to you in the residential or ag district.
Commercial use though.
Pardon?
It's like commercial.
Exactly, that's one end of the spectrum, right?
Yeah.
And then you've got the person doing IT support in their basement. Who cares, right? So where would you draw that line?
If there were neighbors who, I'm genuinely a good human being. If my neighbors complained about anything that was going on, one, I wouldn't do it anymore. Or, I mean, Camille lives directly across the street. Dave and Callie's house is 50 yards, not even from mine. If those were issues, that was causing a disturbance to my neighbors, or, yes, I'm out there with acid spraying them all over the place. I mean, people put Roundup, people come out and put Roundup, all these chemicals that are cancer causing for sure, all over people's properties. And that's okay. I use a product that doesn't even have an STS. It says no information needed because it's that safe, one. And the polishes are on me. They don't go into the ground. They don't go into the air, nothing like that. So when I say, like, I'm advocating for myself clearly, but I'm not saying I'm better or worse than anyone else. It's just that if you make the decision, it moves the goalpost. And then the next decision moves the goalpost. And then where do you end up? Because people are opening new businesses all the time. Because it says auto detailing, right? You're picturing like a pressure washer out there, soap going everywhere. It's not, like, I don't do that. I'm very particular what I do. I polish scratches out of cars and make them look nice. That's it. So,
I have a question. I need to ask a question. I'd like to know why only abutters are allowed to speak at the meetings. Is that something
Yes, you
in the
can.
bylaw?
You wanna comment?
No, anybody who's there should be able to speak.
I thought it was just the butters.
Nope.
Okay, Kimberly, go ahead.
So, I'm just curious, this is just an example, carpenter that works from home, you're saying routinely leaves the home?
Yeah. Like your husband used to,
No, I don't,
just like goes out, works
I
in
don't
other
need to
people's
compare
houses.
anything to my husband.
Mhm.
What if it's a cabinet maker that strictly works out of his home? And someone picks up their cabinets every time he does them, he just never leaves the driveway. He even gets deliveries from Home Depot on
That's
occasion.
not gonna qualify.
Not gonna qualify.
So when
As a
the
home
carpenter's
business.
in,
Cause that's running, we just said, machinery, noise, all that stuff, you're running all those equipment to make cabinets, you're making noise.
so is the artisan though that's making the things and bringing them somewhere else. Planers, everything that the cabinet makers use is going to be loud, much louder than what I do. So that's okay under the artisan rule to bring that away from your property.
No, if you're running a cabinet shop, that's a business that would not be allowed.
That's an artisan. That's the definition of an artisan. Somebody who makes cabinetry and takes it to the, yes.
But it goes on to say works primarily away from the premises.
Right.
That's what I'm saying, yeah. So if you're, but you're talking about impacts of things, of the loud, it won't count because if Home Depot delivers, it's not a home business. You just said that, so.
No, I said, you're running a business out of it, it's more of a business than a home business, is what I said.
Okay, so I'm
That's a
gonna go back.
commercial business.
I'm gonna go back. You said slippery slope is the perfect, everybody says that, but it's 100% accurate. If somebody else is in a position I'm in, I'd be here advocating for them too, because the local small government should not be putting a stranglehold on residents who are just doing things that aren't impacting anyone besides a letter from someone that I don't understand where that even came from, where the information came from. So you are going to impact multiple businesses if this, you rule in favor of the upholding the cease and desist.
Anybody else?
Yes, I have a question. When you single out one individual, when there's multiple people in this town doing similar things, but that one person that was singled out doesn't want to use those people as the examples, because it's then bringing attention if perhaps they're not doing something correct. I'm not saying he knows that for a fact, but I can bet that if he called around and said to A, B, and C, do you have a license? Is this something that has been going on a long time? Do you have permission to do this? Is it customary or incidental? And they say no, no, and no. What are you gonna do if all of these people come forward? There's 200 people that come to a meeting and they say, are you gonna shut them all down?
We only have to, each one that comes to us is one applicant, that's all.
No, I understand that. I'm just asking when one, he clearly is being
So
singled
somebody
out.
files a complaint against somebody.
Yeah,
It goes usually to the building department, and then if they decide to appeal his decision, it comes here.
right. I
So it's a onesie, one by one.
Okay.
Each one addressed separately. Okay.
So why does it take 7 years for this to come to this meeting tonight?
People
We
do
know why.
things wrong for a long time before
And there
somebody.
was someone that had a problem,
So
that's all I'm saying.
Chris, do you do this in your driveway or your garage?
In my garage. I spray rocks, dirt off the vehicle with a regular pressure washer? Yes, of course, right? Like to get the stuff off before I bring it into the garage. But then it's the wipe down of that, clay bar in the garage, polish inside the garage, doors shut. Unless it's 150 degrees, the
So
doors
is
open with a
a
fan.
garage considered a room
It is.
legally?
You asked
Is a
me-
garage considered a room?
In my opinion, yeah, it is. Under the town's bylaws, in my opinion, a garage would be a room as that term is used in bylaw.
Because my original thought was, yeah, someone that's working away from their house. But 3.2.5.1 talks about using a room in the house.
It also says for customary home occupation conducted solely by the resident or more than 2 residents. And the
Do you have-
practice of a
do you have-
recognized profession. That's what we've discussed, said, recognized profession.
You're deciding tonight customary use and organized profession. If that's what this is hinging on, you're making that decision to say that because you clean a car, you're not a professional. But if you're a lawyer or you're a doctor, you're a professional. That's just what I'm saying. So you're limiting residents and putting labels on residents based on what they do or don't do.
So would you say that car detailing is a customary home occupation?
Would IT infrastructure, network, and repair be? No, because it wasn't 5 years ago. There are, I'm not gonna name them because I don't want to do this to anyone else. There are plenty of, I say plenty, there's multiple home-based detailing shops in town.
Okay, but profession, as a principal, this is Webster's dictionary, as a principal calling, vocation, or employment, a calling required specialized knowledge and often long and intensive academic preparation.
Do you know how long it took me to learn how to correct paint and wet sand and take scratches out of clear coat and not burn through the paint? If I gave you a polisher right now, you would burn through the paint in 3 seconds. So I've been training, in fact, I've been to classes, I've been to trainings, I flew out to Florida for trainings to learn how to do it better, more efficient. So if you're labeling me as a resident saying, I'm not professional because I don't hold a doctor's certificate or something, that's pretty bad, because I have a lot of training in what I do. I didn't decide yesterday I'm gonna take swirls out of cars. That's not how it works. And I would like to point out too, This is not my prime. I'm fighting tooth and nail for this because this shouldn't be impacted. Citizens should not be impacted this way. I have a full-time job. I have not detailed a car at my home prior to this complaint, which is the funniest part, for it was at least 2 months prior to that complaint that a car was parked in my driveway. So, very odd, suspicious timing, number one. Number two, it's not something I do. And even now, I could have been doing it because I have the appeal filed with ZBA. I still haven't done a single car. My primary job is very busy. This is something I do. I learned it. I learned the skill, worked in the profession. It is a profession. And I do it because, honestly, it's great mind therapy for me to take a car from looking terrible to making it look, well, not everybody's car looks terrible, but make it look very nice and hand it back to someone and have, you know, that be theirs again. Number one. Number two, I donate so many things to the charities in town for raffle prizes. You're taking that away from people. So, it is in your hands, correct. You're 100% correct. But I think that it's going to impact more than just me. It will 100% impact more than just 212 East Hill Road. Anybody not in a commercial district who's not a doctor, or I guess a lawyer, or that is then under the same scrutiny. And if they're not, if you don't apply it the same to the next person, then I was 100% targeted in this situation.
I have a question. Does anybody on the board know what the definition of customary and incidental?
Why don't you explain that?
Right at the beginning.
You already went through that.
What about custom? It does seem like it just raises the question: how does something become customary? It can't become customary.
If I may,
Go ahead.
with all due respect, this is really not an unclear situation. This is the clearly established law in the state of Massachusetts. Not only that, but I've been doing this for a long time. Lots of other towns have very similar bylaws. The term customarily incidental has been very clearly defined by the courts as what I stated at the beginning here, which is in this situation, since there's an order from the building commissioner, the appealing party has the burden of showing that it's an accessory use. And in order to do that, under the words of your town's zoning bylaw, he has to show that that auto detailing in the residential district has been commonly, habitually, and by long practice established as reasonably associated with the residential use. So, if the appellant came in tonight and had a long list for the last 50 years, or however long, that auto detailing is done, and has been done for a long time in the town, then he might have established his burden of proof.
Can we break that definition
But
down?
I haven't heard that.
Can we break the definition down?
If I could finish?
Yep, sorry.
With all due respect, talking about these other uses is completely irrelevant. It's all about auto detailing, this auto detailing, and again, if auto detailing businesses run out of homes in residential zoning districts, has by long practice been established in the town. That's the burden of proof. And if he could do it, then he would establish it. But it's up to the board to determine whether that burden of proof has been met.
Can we break it? Well, go ahead, yeah.
I just have a question on my biggest issue with it is professional, right? So I am a licensed carpenter. I'm a construction supervisor. I run my business out of my house. You don't need to be a licensed professional to be a carpenter. A carpenter is listed. You don't have to have a license at all to do any carpentry anywhere. You can, if you work for someone else, a homeowner can pull a permit and you can go do the work there. So I guess my problem is what is actually considered a professional. I consider myself a professional. I have a college education, bachelor's degree, I'm licensed, but the same person could not have any of that and still be considered a professional in their business.
I have the same license you have, a college degree and everything else, and it says it has been held that for purposes of zoning classification, a real estate broker is engaged in a business and not practiced like a profession. So wouldn't you think that that's a profession too?
I agree.
But you're
They
defining
say,
professional.
no, it's the vocation that many businesses may have professional aspects. They are not primary. So it's even as a broker, I'm not considered a professional.
Can I ask a question of you, sir? Can you break down that definition then in just accessory use? Just accessory use, not the customary, incidental, none of that, just
It has to go
accessory
through the chair.
use.
It has to go through the chair.
Chris, you have to ask me.
You can't
Oh,
go
I'm
through
sorry,
the
I
chair.
apologize. May I ask through you to break down just accessory use, not the customary, incidental,
Okay.
not that, just accessory use?
Okay. Richard, you may take that.
I'm a little confused by the question, because,
I think the burden of proof that he spoke about before,
well, just reading the bylaw, section 3.2.5.
Okay.
Accessory uses, customarily incidental.
Can you
So
look at
there's-
343,
there's-
please?
There's the requirement, yeah, I know, 3.2.
I'm just, that's what I'm getting to, it'd just be, I heard what you said the first time, so I get that. That just says accessory uses,
Yeah.
so that's also allowed. But that doesn't say customary, incidental.
No, that's.
That's 3.4, that's agricultural, residential, that's where I
That's
live.
where, accessory uses are defined.
What is an accessory use? If we're gonna define it,
Again.
Well, our-
if
once
I
again,
could- If I could
the
answer.
bylaw committee would have had.
no,
If I could
Go ahead.
and that's a very good point, you know, if the town wants to clarify these things, it's all, you know, amendment to the bylaw. But again, the law of accessory uses and what's customarily incidental in Massachusetts is very well established. And again, but like, you know, I've already read it a couple times, has to be by established by long custom that particular use has been used in conjunction with residential uses.
okay, so to follow up on that, Mr. Chair, I'm not asking that definition to be wise, I'm asking because I was originally at 3.2.5, I felt that applied. But agricultural residential districts, 3.4.3, accessory uses, not customary and incidental, just accessory uses. So if we're, I mean, I'm obviously grabbing at things to make sure I'm advocating for myself, but what is your definition of that then? Because that does not say, because that's in 3.2.5, the customary and incidental. 3.4.3 just says accessory uses.
Again, in Massachusetts, the law is really clearly established that what accessory uses are, unless they're like specifically stated in a bylaw, are the customarily incidental applies to determine whether something is an accessory use.
This says, in the Massachusetts law, accessory use or structure is defined as a use, structure, or building that is clearly subordinate to, incidental to, and located on the same lot as the primary building use. And it
But
does,
you're not a separate building.
It's-
You only have one building.
it's still a room, building, it's the building.
That just said separate structure. So that doesn't, you don't fall under that. You're
That's
in
not,
the
I didn't
same
say,
structure.
I didn't say separate structure. I did not say
It's talking
separate
about
structure.
uses.
I didn't say separate structure.
It's not talking about structures, it's the same uses.
Good, read it again though.
In Massachusetts, an accessory use or structure is defined as a use, structure, or building that is clearly subordinate to, incidental to, and located on the same lot as a primary building or use.
Right. A primary building, an accessory structure. It's located on the same lot with the primary building.
So that's accessory use.
Yes, but you are only one building. That's what I'm saying.
What are you reading?
Hold on.
It talks about a structure, then it talks about primary structure. You only have a primary structure. You don't have two structures.
So if my garage was detached from my house, that would count.
Possibly. That's a question for Rich. I don't, you know,
No, so what were you reading?
Hold on.
What was the source of?
I'm gonna pull it right now for you. I had it written down. I have to find it. This just seems like there's a lot of what ifs here versus allowing residents to do what they want to do, and it's not impacting anyone. You're narrowing it down further and further by doing this. So, hold on. I can't find it. I do have it, but I can't find it this time. So I have the only reference of ADUs there. But accessory use is not saying customary incidental to. It's just saying accessory use. So I'm using my room, garage, part of my home, as an accessory. An accessory use of that is me doing a piece on it. It's a garage, sure. But the same thing is converting a home office to your IT infrastructure location where you're doing that. In my opinion.
I'm gonna go back to what the attorney said, is burden of proof. And we don't have anything, I don't know any other person that does this in town.
The accessory use is not bringing that into question though. The customary incidental, yes. Accessory use is not.
In my opinion, the customary incidental applies to the phrase accessory uses. Unless it's something that's specifically listed as an accessory use in the bylaw.
Which
This-
we don't have.
Yeah, but it says those things, but not limited to. And accessory use is separate from accessory use is customary incidental. It's like, I guess.
But not limited to is in a different section from the accessory uses you're citing. That's in
But I'm saying, but you're-
That's in 3.2.5. The accessory uses you're pointing to is in 3.4.
So you're correlating the two, even though they're separate though. You're saying that
No.
accessory use.
No, I'm not. I'm saying Massachusetts law is when you're defining accessory uses, unless it's something specifically listed in the bylaw, the customary and incidental will be applied to it.
What Mass
To
General law is
determine
that?
whether it's-
You asked me where I got my information, what Mass General law
I'm
is that?
citing case law. You want
What's
the
the
case?
case, yeah.
Is that Harvard?
Town-
Go ahead.
It's just the case,
Yep.
reported case of the Mass SJC. Town of Harvard versus Maxent, 360 Mass 432.
Town of Harvard.
V Maxent, MAXAN as in Nancy, T as in Thomas. 360 Mass 432.
My final statement, I'm just encouraging you to not restrict residents on what they do if what they're doing is not illegal. And I have not broken any laws. I did not follow something in the sense that I didn't need a business license. I don't need that in town if I have the LLC. I don't need anything else. I'm not modifying my structure. I'm not modifying anything in my home. I'm just, as the same day I turned the key and walked in, that's how my property is. I didn't put up an additional building. I didn't put up additional anything. I just use it as it is, exactly how it was made before I bought it.
Any other questions?
No, I'm just deep in thought on it.
Me too.
I have to ask a question, kind of not directly related to this. Why are there two police officers here tonight? Huh?
enforcement officer claims it is not a permitted use. And I haven't found anywhere here where it says it's a permitted use, and you haven't proven that. So, I think we move to a vote. Let me, hang on 1 second. So, the relief that was requested was, Mr. Harry voted, was, looking for us to enforce the enforcement of the order. I move that we vote on that at this moment.
I apologize, I just have one question.
It's too late.
Is it possible for him not to continue the hearing so that he could get the truth and come back, rather than be making a decision that he has to go to court and spend money to prove it?
I made a motion.
Yeah, you made a motion.
I made a motion, we already went to vote. You're too late.
Just wanted to know.
Jeff, how say you?
You get a second for your motion?
Oh, so you second the motion? Somebody can second it?
Can you
Did the motion
clarify?
have to be seconded before the question is dismissed?
Well, I mean, you need a motion and,
Yeah.
It wasn't a motion until it was seconded.
yeah, it was a motion, it just hasn't been seconded yet.
Hasn't been seconded yet.
And if I may also suggest that, you might wanna include the entire, not just one part of what he's looking for, to decide the entire,
Okay.
decide the entire appeal.
So this is the entire appeal then. To reverse the enforcement order. Remand the matter for a proper section 3.2.5 determination supported by factual findings, and clarify that section 3.4 requires application section 3.2.5 before concluding a use is prohibited. So my motion was to go
Where is that?
So,
the very last page. Chris's.
Mr. Chairman, if I
Yes,
may,
please.
to vote on whether you're going to uphold that or whether you're going to reverse that, what is the motion?
I was unclear with that. too.
Yea or nay, yes, to support it or not support it.
Should you go through
There's three different points here.
everyone in favor of reversing, and then
We
everyone
gotta get
in?
a second on the motion.
I just wanna make sure I put it in
Okay.
correctly.
Can I see your page?
So you're making a motion on all 3 points at once?
As instructed.
I just want to make it clear whether, the thing that's happening here is whether to reverse or overturn the building inspector's order, or
Right,
whether
but there's
to,
3 different points here that he's,
okay, if you want to do it that way, if you want to vote on each point, that's fine.
Yeah, the way it's written, I guess, he's
it,
requesting 3 things.
because there's 3 different things here. 1, reverse the enforcement order. 2, remand the matter for a proper section 3.2.5 determination supported by factual findings. And 3 is clarify that section, so I don't think one vote is gonna cover all this.
If I may,
Please.
You may,
if you were to vote on the first one, reversing, and you said no, then the other 2 become moot, because it appears to me that they rely on the first thing.
Right.
It would be reversing it, then sending it back. Again, though, I urge you to vote on the entire thing, everything that he's asking for. This is about whether you're gonna uphold the building inspector's commissioner's order or overturn the building commissioner's order, really. That's what this kind of appeal is.
So my motion's out there.
For all 3?
as Rich says, the first one, reversement of the order, if we negate that, then the rest goes away. So can I hold it just to that?
You can.
Okay.
I would suggest perhaps to say and the other relief requested by the
Okay.
petitioner.
I know the motion's been made, but
Yeah, again, the hearing's really over and this is in deliberation. at the
Right.
point, So. you know,
I think he should recuse
Testimony
himself.
is over now, so your ability to really comment,
He
I'm
should
sorry,
recuse
but
himself.
You're the chairman, but.
The
he's
chair
kind
should
of-
recuse himself in this matter, I believe.
Testimony is over.
Okay.
Okay.
So we have the request is to reverse the enforcement office, reverse the enforcement order that our building official set up, that we all read through, and is a cease and desist. So, you know, make a motion to vote in either direction, right?
Yes, you have to,
Just so,
it has
my
to say
motion
which direction,
is-
which direction. It should be a vote to uphold the building commissioner's order
right.
and, and. the
Alright, then my
non-
motion is to, my motion would be to uphold the building department's order. Do I have a second?
To put it to vote?
Yes.
Second.
Okay. Jeff? To uphold those order is the vote. Yes or no?
Yeah,
No.
Yes. So, do we uphold it? We only needed a unanimous decision to break it. So, we decided to uphold this order.
Okay.
So the board has decided to uphold the order of the building department. So the other two matters are moot at this point, correct? Okay. So I make a motion to close the hearing.
You still, yes.
Second, motion to close the hearing.
yeah.
Yes. The hearing is closed. Move on to